Judgment in the appeal in the matter of N children.
Lady Hale will explain the judgment of the court.
This case is about two little girls, whom I shall call Janetta and Ella, although those are not their real names. Janetta was born in January 2012, so is now aged 4. Ella was born in May 2013, so is now nearly 3. The children are of mixed Hungarian and Roma ethnicity. Their parents are both Hungarian, having come here in search of work in 2011. The children were both born here and have lived all their short lives here, but they are citizens of Hungary. When Ella was born at home, without any antenatal care or medical attention, the authorities had to intervene to protect both girls from harm because of the conditions of extreme squalor and deprivation in which the family was living and the refusal of medical attention for mother and her newborn baby. Janetta was placed in foster care that day, and Ella was discharged from hospital into foster care when she was 8 days old. Janetta joined her in the same foster home shortly afterwards, and they have lived there ever since. Their foster carers would like to adopt them. The local authority brought care proceedings and made inquiries to see whether there were any family members in Hungary who could look after the girls, but none was suitable. The Hungarian Central Authority proposed that the proceedings should be transferred to Hungary, whereupon the girls would leave their present placement and be placed in foster care in Hungary, and insisted that only the Hungarian authorities could order the adoption of a Hungarian child. The European Union's Brussels II revised regulation governs jurisdiction as between member states in matters concerning parental responsibility. The primary rule is that the courts of the state where the children are habitually resident have jurisdiction to decide these matters. This includes care proceedings brought by the authorities to protect a child from harm. These children are undoubtedly habitually resident here. They have never lived anywhere else. However, there is an exception. Under Article 15 of the regulation, a court here can decide to ask a court in another member state to assume jurisdiction if 3 conditions are fulfilled. First, that the child has a particular connection with that state, including, as here, being a national of that state. Second, that the court in that state is, quote, better placed, end quote, to hear the case than the court where the child is habitually resident. And third, that the court here considers that transferring the case would be in the best interests of the child. In this case, an application to transfer the case to Hungary was initially refused. The High Court then determined that the children were at such risk of harm in their parents' care that the conditions for making a care order were met. But at a later hearing, the High Court, having heard all the evidence and arguments about what placement would be better for the children's welfare, declined to decide that question and instead made an order for the transfer of the case to Hungary. The judge decided that a Hungarian court would be better placed to hear it. He also decided that in considering whether the transfer would be in the best interests of the children, he had to ignore the fact that the transfer would rule out one possible option for their future, which was to stay in the placement where they had lived for virtually all Ella's life and for most of Janetta's. The Court of Appeal upheld that decision. The children's guardian appeals to this court on their behalf. This court unanimously allows their appeal. The requirement that the transfer be in the child's best interests is intended as an additional safeguard for the child's welfare, to respect the child's right to have her best interests treated as a primary consideration when decisions are made affecting her. In this case, the transfer would rule out one possible option for the children's future. It would also mean uprooting them from their stable home and transferring them to a foster home in Hungary without any assessment of the impact which this would have on their welfare. By contrast, keeping the case in this country would not rule anything out. If the court decided that it would indeed be better for these Hungarian children of mixed ethnicity to be brought up in Hungary, where they might be able to retain links with their parents and other relatives there, there are ways in which an English court can arrange this. But the court might decide that it was better for them, if they could not be returned to their parents and there was no suitable relative able to look after them in Hungary, to remain in their present home. Again, there are ways other than an adoption in which this can be arranged, although adoption would be an option. The courts here are very conscious that our law is unusual in that in cases where it has been proved that a child is suffering or is at risk of suffering significant harm in her parents' care, it is possible to dispense with the need for the parent's consent to an adoption, where the welfare of the child requires this. But this most drastic interference in family life is only permissible where nothing else will do. There are other ways of providing for the stability and security which all children need. This is something which the judge will have to consider when the case goes back to the High Court for the children's future to be decided there.
The court is now adjourned.